The High Court was told on Tuesday that the corruption charges filed against former Prime Minister Tan Sri Muhyiddin Yassin was not discriminatory in nature. Deputy Public Prosecutor Dato' Wan Shaharuddin Wan Ladin submitted that this was because all the charges met sections 152, 153 and 154 of the Criminal Procedure Code by stating that the form of the charge, particulars as to time, place and person accused, and the manner how the offence was committed. He said Muhyiddin's rights according to Article 5 of the Federal Constitution had not been violated since the trial of the case had not started. Wan Shaharuddin was arguing on Muhyiddin's application to strike out the 4 charges made against him in the hearing before Justice Muhammad Jamil Hussain. Meanwhile, Deputy Public Prosecutor Ahmad Akram Garib said, since the beginning, the prosecution had given notice to the applicant that there was no obligation under the law for the respondent to state the manner of abuse of power committed by the applicant in the charges. He requested the court to dismiss the application and said all the charges that Muhyiddin was seeking to strike out clearly stated the elements of the offence under Section 23, subsection 1 of the MACC Act 2009, that is, Muhyiddin in his capacity as a public officer at the time, namely the Prime Minister, had used his position to obtain bribes of 232.5 million ringgit. Muhyiddin's counsel Dato' Hisham Tepote in his submission said all 4 charges of abusing position were bad in law and defective in nature, as the respondent had failed to particularize how his client had allegedly committed the offences. Judge Muhammad Jamil fixed August 15 to decide on Muhyiddin's application, which was filed on April 18.